A continuación, tendremos el honor de escuchar al señor Graham Smith, comisionado adjunto y director de Libertad de Información de la Information Commissioner Office, ICO, del Reino Unido. Abogado con estudios de posgrado en legislación y práctica de gobiernos locales de la Universidad de Sheffield, nuestro invitado se desempeñó por más de 20 años trabajando para diversos gobiernos locales en Inglaterra y hoy, como comisionado adjunto, es el responsable de la promoción y el cumplimiento de la libertad de información de la ICO. La exposición del señor Smith será traducida simultáneamente, por lo que les pedimos a quienes lo requieran preparar sus receptores a partir de este momento. Nuestros asistentes estarán disponibles en caso de alguna necesidad. Recibamos entonces con un gran aplauso al señor Graham Smith.
Good morning, ladies and gentlemen. Buenos dias. I'd like to start by thanking the Council of Transparency for the invitation to speak to you here today. It's a great honor for me to be here to talk to you from the United Kingdom, and it's a real pleasure for me to have my first visit here to Chile and to Santiago. I'd like to thank Jorge, the President, for his kind words, particularly to me in English. I'm afraid my Spanish isn't as good as his English, so buenos dias is as good as it gets. I'd like to, before I start, congratulate the Council of Transparency on the achievements that it's made in its first 5 years. You've just heard about some of the great progress which has been made in Chile with transparency during that short time. And I'd like to tell you that the Council of Transparency in Chile has an excellent reputation internationally among the community of information commissioners for the very good work that it does. And so, as I say, I'm delighted to be here and participating in their 5th International Seminar. Now, what I'd like to do is talk to you a little bit today about the role of the Information Commissioner's Office. I'd like to tell you something about the introduction of the Freedom of Information law in the UK and the progress that we've made, and some of the problems that we face with still with transparency and freedom of information. The UK is not so different to many other countries around the world in terms of the way that governments sometimes struggle and authorities sometimes struggle with the concept of transparency. And I'd like to finish with some reflections on where we are now, how things are changing and what the future might hold for the transparency agenda. So in terms of the role of the Information Commissioner's Office, our mission is to uphold information rights in the public interest, promoting openness by public authorities and data privacy for individuals. Now, I just realized that excuse me a moment because I've not got the right presentation on the laptop. I should have checked this before, but I've got the presentation which I'm giving to the Council on Friday. So I don't know if somebody can come and help me here and get the right slides. But in the meantime, I'll continue talking to you from the notes that I have. So to tell you something about the Information Commissioner's Office, yeah.
Where's your presentation?
It looks like this one.
This one is in the pen drive.
that's-
Okay, all right. Give me a second.
Okay.
Right.
So the Information Commissioner's Office was established initially for the purposes of data protection only, because we've had a data protection law in the UK now for almost 30 years, and the Office of the Information Commissioner has grown out of the Data Protection Commissioner's Office. The Information Commissioner is an independent post. It's independent of the government. With our constitutional arrangements in the UK, the appointment is technically made by the Queen, and the Commissioner reports to the Parliament and is directly accountable to the Parliament. His term of office is for 7 years, so the current Commissioner, who is Mr. Christopher Graham, is in office now until the summer of 2016. And during that term of office, he can only be dismissed from office by a resolution of both Houses of Parliament. So from the point of view of job security, we say in the UK, this is really as good as it gets.
Sorry, yeah, I'm going to let you out.
Okay. So the Information Commissioner's Office is responsible, as I say, for both data protection and also for freedom of information. The data protection work that we do accounts for about 80% of the work of the office. Data protection in Europe flows from a European directive, and to this extent in law, the rights of individuals to privacy takes legal precedence over the right of access to information for citizens. As I'll reflect later, the right of access to information for citizens is a legal right in Europe. It is not a constitutional right, and so I've been interested to hear about the progress that is being made and the proposals in Chile for embedding the right of access to information in your constitution. Of course, in the UK, we don't have a written constitution as such. But there is much discussion in the courts and among bodies interested in transparency to understand how the right of access to information fits with the fundamental right of freedom of expression. And we've had a recent court case in the Supreme Court of the United Kingdom which has held that the right of access to information under English law does not engage the right of freedom of expression under the European Convention of Human Rights. So this continues to be a debating point for lawyers and academics. So the theme of your conference here today is actually very, very interesting for those of us involved in transparency, also in the UK and in Europe. Now, the law on freedom of information in the UK was introduced by an Act of Parliament in the year 2000, but it didn't come fully into effect until 2005. And so while you're celebrating 5 years of access to information in Chile this year, next year we will be celebrating 10 years of freedom of information in the UK. But of course, the political context, the social and economic context for our law perhaps has been somewhat different, and indeed in many respects some people question the need for a right of access to information, believing that the government was actually transparent anyway. Interestingly, compared to your experience here in Chile, it is local authorities which have the best tradition of transparency in the United Kingdom, because as was said here by your President of the Council, local authorities are closest to the citizen, and we have had processes for citizen participation in decision-making in local authorities for some time, and their meetings and their proceedings have been open to the press and public for almost 100 years. So the culture change for local authorities on the introduction of a freedom of information law was not as great as it was for some other parts of the public sector, including the central government itself, and also the health service, the education service, and the police service, and others. So what benefits have the freedom of information law in the UK brought to us? Well, the first and most important thing is that it is an enforceable right for all citizens. The Information Commissioner has the power to order, to direct the disclosure of information, or to order a public authority to do other things to ensure that it complies with the law. And those rulings from the Commissioner, although they are subject to a legal appeal to the courts, if they are not appealed successfully to the courts, they are binding in law, and they are punishable as if a court order has been breached, which in UK law is called contempt of court, and this is punishable by an unlimited fine, or possibly the imprisonment of an individual who is responsible. Now, in terms of raising awareness and ensuring compliance with the law in the UK, we have never had to resort to these powers. So we have never had to ask a court to fine or imprison somebody for failure to comply with the transparency laws. But if you come up against some opposition, and somebody is saying, well, why is it that I have to comply, and what will happen if I don't comply, then the ultimate threat of imprisonment is something which usually helps to persuade them of the importance of complying with the law of transparency. But as I say, it doesn't usually happen, and our powers are recognised as strong, and the extent of compliance in the UK with the Freedom of Information Law is very good. So the other benefits for the citizen is that the right of access to information is free. There is no application fee for asking for information from a public body, and any request simply has to be made in writing. You do not have to say that you are seeking your information using your rights under the Freedom of Information Act. So the citizen doesn't actually have to know that the Freedom of Information Act exists as a piece of legislation. They just need to know that they can ask for information. Of course, people have been asking for information from public authorities long before we had a Freedom of Information Act. What has changed with the Freedom of Information Act is that there is now a legal framework which has to be complied with. Another important aspect of making a request is that nobody has to give reasons for wanting the information, and they don't have to say what capacity they are seeking the information in. Obviously, journalists make a lot of requests for information, and many of them will say that they are a journalist, or it will be known by those who are receiving the request that this is from a journalist. But they don't have to say that they are a journalist, and journalists have no special rights of information under the Freedom of Information Act in the UK. They have the same right, no more and no less than any ordinary citizen. Only a name and address for correspondence is required. There is no need to demonstrate residency under the current law. A request can be made, and indeed requests are made from anywhere in the world for information from a public authority, and indeed the information is usually requested and transmitted electronically. And finally, an important aspect of the law that I want to highlight is that there is a statutory duty on public authorities to advise and assist people who are trying to make a request. So if somebody approaches an organisation for information, the authority has a duty to advise them how to make the request. If they are not at the right office, if they need to go to another government department, they are obliged to tell them where to seek the information from. And if the information request isn't sufficiently clear, then it cannot simply be ignored. The public authority has to seek clarification and suggest ways in which a request might be clarified to help the requester get the information that they want. The Information Commissioner then intervenes and is approached when a citizen does not get a response to information, to a request for information that they are satisfied. And I believe this is very similar to the role that the Council for Transparency has in Chile. So we handle complaints of non-compliance, but we also have, thank you, we also have a role in educating the public and raising awareness of the rights under the Freedom of Information Act. When we're deciding how to consider complaints, then there are some key disclosure principles which we adopt and which we take into account, particularly when we are considering the public interest in the disclosure of information. As with many regimes, we have a situation where information may be regarded as exempt, so there is a reason for non-disclosure under the law which is set out in the law, but many of those reasons for disclosure, indeed most of them, are subject to a public interest test, which means that if the public interest in disclosure is greater than the public interest in withholding the information, then it has to be disclosed in any event. And this is where many of our judgments about disclosure are made. And here are some of the things which we take into account in very many cases. So the first thing is that freedom of information is an important tool for accountability for public expenditure. The Undersecretary talked about the importance of not only knowing what a government does, how it does it and the reasons why. One of the things that people are most interested in, certainly in the UK, is how much is being spent on a particular project or a particular item, or even a particular senior official's salary or expenses incurred in the course of their duty. And this is a key reason that we see for disclosure in the public interest. The reasons why decisions are made so that citizens can better understand why public authorities are doing what they are doing. This again is very important. So you look at what reasons and reports are already in the public domain and consider what additional reasons and additional benefit there would be to the public understanding the further information which has been requested. Accountability for decisions, again, is a key principle for us. Who is the person who is responsible for the decision? Are they properly legally entitled to make the decision? Are they accountable for it, and what accountability mechanisms exist for ensuring that decisions are taken properly and in the worst cases that power is not abused by being exercised by people who do not technically have it. And one of the most difficult areas, which I think applies in all transparency laws and for all commissioners and councils for transparency, is balancing the public interest in the disclosure of information against the private interests of citizens involved. And very often the information which is requested engages the rights of private citizens, and this is where our role in the UK Information Commissioner's Office of having responsibility for data protection, which is the European law on privacy, whereby private personal information of individuals is kept secret legitimately, how this is balanced with the public interest, particularly for officials or people holding public office or people working in government, where do their private interests finish and the public interest in the disclosure of information about their activity and their expenditure and the decisions that they make in their public life, where does that start? So finding this tipping point as to where something ceases to be a private interest which should be protected and becomes a public interest which points to disclosure of information. Where this lies as an individual case is a very important judgment that we have to make. We always recognise, and this is important, that the exemptions in the Freedom of Information Act exist to protect genuine public interests in certain cases. Some exemptions are there to protect the national interests, so national security, international relations, defence. These are key important issues which, although under our law they are subject to a public interest test, we recognise the very great public interest in protecting the national interest in security and international relations, and ensuring that proper diplomatic relations can be maintained because the rules of engagement and confidentiality are respected is very important. As is the need, of course, to protect personal interests, and this can be the personal interest of an individual who may be subject to a criminal investigation or some kind of financial investigation. You have to, again, identify the point at which there might be a public interest in disclosure, but where, for example, the individual's right to a free trial is concerned, that will take priority over the disclosure of information. So those are some of the key principles that we apply when we are determining the outcome of complaints. In terms of achievements, it's true to say that in the 9 years that we've had freedom of information, a lot of information that was previously secret has now been published. And the right of access to information is a very popular right for citizens. It is true to say that it tends to be exercised by a certain sector of society who are well informed, who will be tending to participate in the democratic process anyway. But what's very important in the work that we do and some other citizens' advice organisations do in the UK is drawing attention to the right of access to information for ordinary people. And as has previously been said already today, one of the biggest challenges, but also the most important aspects of access to information is to ensure that it is used by citizens who recognise the benefits in their ordinary lives. And this is where, for us, the most complaints come. So local authorities, hospitals and schools receive very many requests, and if they are not properly respected, this is where we get complaints. So whilst there are very high-profile complaints to the ICO which concern major government projects, and these are the things that get most coverage in national newspapers and are most concerned to the government and involve some very difficult and controversial decisions. In numerical terms, this is very much the minority of the complaints work that we handle, and the vast majority is to do with ordinary people dealing with local issues which are important to them. Now, the media play a very important role in keeping freedom of information in the spotlight. Journalists and broadcasters frequently refer in their news stories where they've used freedom of information to the fact that the information behind the story has been obtained under the Freedom of Information Act. So from the Information Commissioner's point of view, this is great news because every day in the newspapers and every day on the radio or on the television news, everyone is hearing about the Freedom of Information Act. And so the spotlight continues to be on us. But also there have been some very high-profile cases which bring to people's attention the importance and the achievements of freedom of information. And here are a few of the issues which either have been or are still very current in the UK. The biggest single case has been around MPs' expenses, which was a scandal in sort of 2008, 2009 in the UK, where freedom of information requests combined with very effective journalism resulted in the disclosure of weaknesses in the system of MPs' expenses and some scandals as to the way some abuses of the expenses regime had been taking place. But perhaps even more concerning was the fact that many cases had been dealt with and MPs had acted entirely properly in terms of claiming what they were entitled to, but it was a surprise to ordinary citizens to understand what the nature of the regime was and what people could claim in terms of their expenses. And this has led to a complete overhaul of the MP's expenses system, which is now extremely transparent, and a separate independent body has been set up to administer the system. It is subject to the Freedom of Information Act itself, and it is one of the most transparent organisations in the UK. They have a very good website where they publish extensive details of MPs' expenses every month. There was a major football disaster in the UK. We've just passed the 25 years anniversary of this football disaster. But freedom of information requests have been very important in understanding the conduct of the emergency services, the activities of the police, and there has been some police corruption exposed as a result of work which has been carried out through a public inquiry, where police officers falsified some of the statements as to what had happened. This was 25 years ago. At the same time, freedom of information requests were made to the government to understand what the Prime Minister and the Cabinet were being told about this disaster. And interestingly, this was one case where the public interest, we felt, was greater even than that in the conventional secrecy of cabinet, so ministerial discussions, and we ordered disclosure. One of the things that was interesting was that actually the Prime Minister at the time was being very objective, was being very measured in the approach that she was taking, and was not jumping to conclusions, which was the suspicion. So transparency can help to improve trust. Has been said, even in this case it was a historical perspective, but it's not just about confirming suspicions, it's very often about revealing good government and demonstrating through transparency that government is acting properly and as it should. And another case, I won't talk about all of these, but Chequers is the country residence of the Prime Minister, the official country residence of the Prime Minister, and a freedom of information request was made by a BBC journalist to know who had been invited as guests to official dinners there, because this was all at public expense. And there was a tussle some years ago with the government. This was the time when Tony Blair was the Prime Minister. And reluctantly, following an order from the Information Commissioner's office, the list of the dinner guests was disclosed, and now it's routinely disclosed, and there is no issue about it. Nobody remarks about it, because with transparency, what might be news and good gossip is no longer exciting. A few problem areas that we still have, I've identified some of these, and I'm conscious that we're running out of time. I've talked about the importance of identifying the boundaries between public life and private life. And we have a new challenge with the disclosure of big data, open data, and data sets, about making sure that personal information is truly anonymized, and that with data mining techniques, that individuals cannot actually be identified from matching apparently anonymous data sets about individuals, sort of health information or education information, which is important for identifying statistical trends and problem areas, but it's important that personal information is protected. There continues to be concern, particularly at government level, about the unexpected, sometimes, transparency in terms of advice to ministers. We respect the need for ministers to have that safe space for working on major issues, but sometimes the public interest in disclosure is greater. And just to finish with a few thoughts about the future. One of the things which has changed, I'm sure the Council are finding this even in their short 5 years, certainly since our Act was passed in 2000, the whole technical issue of access to information, political drivers, social drivers, the use of social media has grown exponentially, and therefore this presents new challenges for implementing a law which was really in the UK designed for access to paper records, and we are applying an old law to new technology and new forms of communication. And I think it's going to be interesting to see if the UK follows what has happened in some of the jurisdictions which have had freedom of information laws for a long time, such as Australia and Canada and New Zealand, where they have had to review their laws to take account of modern technology and modern forms of communication. Citizens have high expectations of transparency, and we're seeing this new phenomenon of open data, much promoted by the Open Government Partnership, and the reuse of information for reasons that it was never collected by the authority for. So the development of apps and new technological applications. So, and it's important that as these things change and more information is freely available, that we still recognize the importance of preserving and protecting the right of access to information. Because the open government agenda seems to me to be very much about governments putting information in the hands of citizens that they want citizens to have. And the importance of the right to make an access to information request and to have an independent body such as the Information Commissioner's Office or the Council of Transparency to enforce that right is so important, because that's what we call it, the push and the pull. The government likes to push information out, but there is some information that it doesn't want to give out, and so the citizen, through freedom of information law, has to pull it from the government and to draw it out from the government. And that is the area where there will always be some tension, but it's important also that we respect the genuine need for secrecy and for privacy in some important cases. Thank you very much.